Mr. Chairman, members of the committee, my name is Tom Biglen, B-I-G-L-E-N. I'm on the board of directors of the American Civil Liberties Union of Montana, and I'm a former county attorney. I am here today to testify in support of abolishing the death penalty in Montana. I grew up in Big Timber. I was in the military for 3 years, served a tour in Vietnam, and left Vietnam, and I thought, I think I'm going to go home and I'm going to stay there. I like Montana a lot better than I like Vietnam. I was elected Sweetgrass County Attorney in 1982, and I served until 1997. My testimony today is grounded on the principles that prosecutors are bound to, very simple principle, the rule of law. In the field of criminal law, the Montana Constitution sets forth the policy that guides us and mandates our adherence to the rule of law and the rights of the convicted. The Montana Constitution Declaration of Rights states, and I quote, "Criminal justice policy, rights of the convicted. Laws for the punishment of crimes shall be founded on the principles of prevention, reformation, public safety, and restitution for victims." I have quite a bit here that I was going to go into those matters in a little more depth, but already today, Ray Crone, Carolyn Madplube, and Bishop Thomas have given you the underpinnings of what our Constitution already tells us on prevention, that every violent crime I prosecuted as county attorney occurred while the perpetrator was in the throes of a high emotional distress, under the influence of alcohol or addictive drugs, or did not have the mental capacity to evaluate the criminal conduct. For the death penalty as prevention, it is my contention, and I knew it when I was prosecuting cases, that it's not the deterrent that it sounds like on paper. People act very emotionally. They don't consider their acts. I don't think under the Constitution, I contend under the Constitution, it is not something that benefits the prevention of that type of a crime. Reform is a societal, it's a Christian expectation, and in Montana, it is a constitutional requirement when prosecuting and sentencing criminals. You take into account reform. An offender under a life sentence without the possibility of parole always has the chance to reform. That person may become model prisoner, have a spiritual awakening, or just exist. A person executed does not have the benefit of the constitutional mandates to reform. Public safety, I was going to speak to that, and it's a very, very important part. You've already heard some testimony on it. I had some conversation with Ron Waterman that I was going to pass on, but Ron Waterman is here today, and I'll let him do that on what the costs are of the capital punishments. I'd like to spend a couple of minutes on my personal perspectives, what I learned as a county attorney. When a big crime hits the media, the easy approach for any county attorney, and Ray Crone talked about this very, very well, is to go hell-bent for leather for the toughest, most aggressive result that can be obtained within the law. That didn't work for me, and it doesn't work for most county attorneys. That's not the way you approach it. You approach it under the rule of law that I spoke to you about. I also heard a lot when I was studying and working on this as the plea agreements, that the death penalty gives the prosecutor something in their hands, power, to say, if you don't do something, this is what could happen, let's talk. As we all know, a lot of cases go to plea agreement. I contend under the law, under our requirements as a prosecutors, that's not the way you do it. You look at your case, you look at your evidence, you look at prevention, you look at the safety of the public, you look at reformation, and you work a plea agreement based on what is in front of you, not on a tactic. And that, to me, what that argument about plea agreements is a tactic. While I was county attorney, I watched my small county struggle every year to provide adequate funds to its law enforcement agencies. One capital case, just one capital case, can devastate a small county's budget and it can even cripple the not-so-small counties, as Gallatin County experienced in just the past few years. Funds that could have provided for good law enforcement to provide public safety go into the cost of the death penalty prosecutions, it goes into the determination of penalties and appeals and appeals and appeals, which more often than not end up being kicked out of the death penalty status anyway for a variety of procedural and substantive legal reasons. And finally, and I heard Ray Crone last night and I heard him again today, and I really want what he had to say to sink in, because it works both ways if you're working under the rule of law. It works both ways, to the prosecutor and to the defendant. There's always the chance that the wrong man can get again, the wrong man or the wrong woman can be convicted. I can think of no more dreadful result for a prosecutor than to get the wrong man or woman. There are instances of second chances for convicts serving their terms, and there are numerous cases on the record where exoneration occurs after the conviction. For someone wrongfully executed, there is no second chance. Yeah, I propose to you, thank you, ladies and gentlemen, I propose to you it's time to end the death penalty in Montana. Thank you.